Law School Secret Series 11 Crimes Against the Person Continued Part 4 Homicide Continued with Defenses. Hi everybody, welcome, so glad you're here. I subscribe to Gandhi's saying to be the change you see in the world, and I'm going to try to help you out. Law school's tough, and so are exams, so just realize that I'm going to be throwing some notes out here for you to pause and read if you want. Earlier videos might show more information. I'm building on some slides and an outline. The general outer outline looks like this. I strongly suggest you have an outline. If you're new to my channel, this is 11. If you want to go into details, some of the slides I pulled out, others I added on, and I'm just doing like an audio with it. Later on, I'll be making some MP3 files so you can take it with you wherever you go. However, right now what I'm doing is I'm making the videos, and then the last one I'll turn into an MP3, and you can, listen to it in your car or something. Anyway, so Part 4, Crimes Against the Person, Homicide, and Defenses. Now, I'm not going to go into detail over homicide. I covered these cases before. I covered details on, context when you're talking about a homicide, feticide, death. The prior slide, the prior videos will show you more on that. And I also discussed this before, but I'm gonna slide through it and just talk to you and narrate this a little bit. But if you want to pause something, go ahead. Also, feel free to review the older videos over and over if you want to get more detail on it. So anyway, let me just flip through these slides real quick and then go where we left off, because what I did is I just built on that. I did cut some out. So let's see, where are we? If you look at the bottom, there's slide numbers. So if you have a question, what you can do is say, hey, slide 28, did you mean this? Or, if you want to ask a question, you can refer to the numbers on the bottom. So, oh yes, see how this says causation C6, the other one said, or C7? This is where I go into a little bit more detail on it. I might talk about a few cases. Now, accomplice liability. This is AL. I use the abbreviation AL. When you have homicide defenses and crimes, even though you didn't do something, you might be held liable as an accomplice. Now, in Criminal Law 5, I talked about some basics with that. This is a little bit more of a build on it, but you need to know these categories at common law, and then a misdemeanor, if it's a misdemeanor, or if it's felony. And you do have misdemeanor manslaughter, but I mean, you have the felony murder rule, and I'm going to get more into that a little bit later, but these are the categories. If you're filling in an outline, studying for finals, you might want to look at that or work on that. Now, with homicide, certain defenses aren't going to work in homicide that would work in another crime. Recall there were categories of homicide or murder, and there are justifications or defenses. So they categorize it by justification, excuse. So these are justification type things you might bring up. Oh, it was self-defense, it was defense of property, defense of others, and of course law enforcement and necessity. Self-defense. Now, a defendant's permitted to use reasonable force to prevent an unlawful attack, but the degree of force is usually non-deadly unless they're threatened with imminent serious bodily harm, and it has to be a reasonable belief. And there's also the initial aggressor doctrine. And basically, if you started it and um, you're holding a gun to somebody and then they whack the gun out of your hand, you're the initial aggressor. So don't tell me, you can't use that defense. Now, with retreat, the courts are divided on that. Now, the minority at common law, the retreat rule, deadly force is not allowed when retreat is possible. And the majority, there's no requirement to retreat. Defense of property. In very limited circumstances, the defendant may use force to defend their property. However, deadly force usually only can be used when the defendant initially used non-deadly force, which was met with deadly force or were a violent felony intrusion into the defendant's dwelling. Defense of others. Deadly attack, special relationship, majority not required, minority requires you to step in the shoes, majority allows a reasonable mistake. Crime prevention, law enforcement defenses. At common law, deadly force may be used to prevent a felony. Now remember, this is law enforcement. If you're not a law enforcement person, it doesn't apply. Now, modernly, deadly force is limited to present danger. Police may use to prevent a dangerous felony with danger to persons. Necessity. Rarely, necessity is a defense, where the defendant committed the crime because of non-human circumstances and the harm avoided is greater than the harm committed by defendant. Now, there's going to be cases that you might have read about, situation ethics, for example, the Dudley case, Dudley and Stevens in England, 1884. They were out on a lifeboat. They were stranded, days without food, and they killed a young, scrawny kid to eat because they thought the kid was going to die anyway, and it was a necessity. They thought they weren't going to survive or get saved. Well, the judges did not buy that. But that's where, a case where necessity was used, and of course they were convicted. But there's going to be cases where they use it, but it's not going to fly. I mean, very often. It's pretty rare. Okay, so excuse. Now, there's some insanity defenses, and I think, I forgot to list this, but infancy should be in here. So anyway, these are the main ones. McNaughton, Irresistible Impulse, MPC. Durham is not used that much, but we'll go over it. Now, the McNaughton test. The defendant at the time of his conduct lacked the ability to know the wrongfulness of his actions or understand the nature or quality of his actions. And this is based from a case in England, Queen versus McNaughton. And it is the majority common law rule. Irresistible impulse. This is a test applied when the defendant had a defect so strong they couldn't help themselves. They lacked the capacity to control themselves. This is adopted in a minority of cases as a form of the insanity defense. MPC has a form of this. If you look at the MPC, you'll see them talking about a defect, strong defect, and whatnot. But anyhow, this is the main part of the MPC, the substantial capacity test, it's called. Defendant may use the substantial capacity defense if the defendant lacked capacity to appreciate the criminality of their conduct and conform their conduct to the requirements of the law. Now here's the Durham rule. In a minority of jurisdictions, this is rarely used. It's the but-for cause of the crime. In other words, the mental disease or defect was so severe that it caused them to commit the crime. Now, infancy is doesn't usually come up in murder cases, but occasionally it might. I recall a case on the news where a young mother had a pistol in her purse, and her 2-year-old, she went shopping. She put the baby, the 2-year-old, in the top of the cart, and the gun was in her purse. Baby took it out and shot his mother and killed her. Now, that 2-year-old, if they wanted to take the 2-year-old to court for murder, they've got the infancy defense right off the bat. I mean, incapacity. They're not capable of committing a crime. They're under 6. Now, there's a rebuttable presumption between 7 and 14, and then there's an adult over 14. Normally, this doesn't come up too much, but it is a defense. Intoxication. Now, there's 2 types of intoxication. There's voluntary and involuntary, and involuntary is gonna fly. This is if somebody drugs you with something like DMT or acid or LSD or something, and you don't know you're drugged and you're intoxicated, and you do something under the influence like that, that is a defense, but you're going to have to prove it. Now, with the voluntary intoxication, it's not a defense, usually to crimes involving malice, recklessness, negligence, or strict liability, but if it's a specific intent crime, it can be used. So, diminished capacity is not really, it can be used to mitigate a crime. In other words, it's not a complete defense, but if you are incapacitated or you have diminished capacity, words are used interchangeably, it will negate a specific intent crime in areas where it's recognized. It's an impaired mental condition short of insanity, which is caused by intoxication, trauma, or disease, and prevents a person from having the mental state necessary to be held liable for a crime. Now, the Deific decree doctrine, a person is considered legally insane if the result of a mental illness he believes that God personally spoke to him and ordered him to commit a criminal act. Now, next time, we're going to talk about crimes against property, the sex crimes, and general defenses, and then I'm going to move on to another subject unless somebody points something out that I missed or skipped over, and I might be able to elaborate and throw up a quick video on that. Here are the references. These are the images I pulled. And hey, as always, I just want to thank you and wish you well in all your endeavors. Namaste. Please like, share, and subscribe. Have a great day.